few moments later.
What is up, everybody? It's your boy Legal Mindset here on, well, The Legal Mindset. We teach you to be your own judge. Gonna have a good one today as we go down this road, rebutting a major argument regarding the Gina Carano case, which is going to be debunked tonight, and debunked solidly, debunked like a rock, like a Chevy. We're gonna get this one put away because it is indeed a major argument, which I think other people may bring up. So we're going to take this down tonight, and we're going to take it down to Disney Town. Guys, make sure as you come in, you smash the like button here tonight. We have 183, almost 200 people on YouTube. On Rumble, we almost have 100 already. Wow, Rumble's like catching up right now to YouTube, and I'm sure we'll get more in here today. And we are just, I have a limited time tonight. So this is not a time in which I can cover every single possible thing. So let me just mention that right now. So this isn't going to be a stream where I'm going to go through every single statement that's made on Gina Carano since last time. Also, I do want to give, before we start here tonight, I do want to give an honorable mention to uncivil law. So I did the rankings, and when I did them, at the time I did them, either it wasn't up or it was after I already streamed. I'm not sure when. I think it was after. So after, I believe Kurt of Uncivil Law put up a video on Gina Carano case. Now, I have not listened to it, so it's not fair for me to review it. It's not fair at all. Some people in the comments have said Kurt says it doesn't have a good chance. I'll maybe listen to it at some point and try to get the TLDR on why he thinks that. But of course, I don't have time to watch a bunch of 1 hour and 30-minute videos, right? I only have so much time to review what's pertinent and kind of get to the heart of the issue and get to the major legal arguments against it. And let me just point out this, and this is one thing that I want everybody to know here. And by the way, with Kurt, I think some people in the comments got a little bit salty. They're like, why didn't you cover Kurt? Why didn't you include Kurt? Well, I think they were viewing my video after Kurt had put his up, but way after I had streamed. So whatever, it wasn't I was forgetting about Kurt. It was just the timing of the video, right? The video came out. I think Kurt's video came out after mine, right? So that was the issue there. I love Kurt. No lost love there. But let me say one other thing, and this is very, very important, right? No lawyer who calls himself a lawyer, right, should ever be intimidated by somebody analyzing their legal analysis, right? So going through their train of thought and breaking it down and coming up with a point or a counterpoint. No lawyer should be intimidated, offended, mad, salty about that, because that's the whole point of being a lawyer, right? In the first place, is that you can indeed have two different lawyers who look at things different ways. That's normal. That's quite normal. So I think for any and all of us, I think we should always be comfortable with that. And in that way, disagreement, I think within lawyers is kind of normal. It's kind of, when you're looking at somebody else's legal analysis and you're saying, hey, I don't like it, I don't agree with that. You might agree with them on a different case or a different issue, right? Let's say you guys agree on Amber Heard, but maybe there were people that disagreed on the Ahmaud Arbery case. And that's truly, we've seen this play out, where people will say one thing on one case and say another thing on another case. That's normal. That's how lawyers work. And let me get these chats now. Some of these I think came in before I was online. So for some reason, StreamYard did not log them. So I want to make sure I get everybody here. First of all, shout out to who was first here today. He's Dead Jim. So shout out to He's Dead Jim. Appreciate you in the chat today. Who I think was the first one here today. So shout out to the number one in the chat today. Also shout out to the members of the BLM, all the guys coming in today. Also Ice Cole, welcome as a new member. I believe you're a member of the RPG, the replay gang. So you're gonna get all the replays, emojis, etc. Chinninator said, why you give Drunk Kata an F? Well, I mean, I'm going to be reviewing his follow-up today, and we'll upgrade his score. We'll move him up to a different score. The reason why, and this is something that I think people maybe did or didn't understand, was because it didn't appear like he read the complaint. And it does appear like subsequent to my video, he's gone and read the complaint, at least partially, right? I wasn't able to see all of Nick's stream. Of course, Nick streams for multiple hours. I don't have 8 hours a day to follow all Nick Rekieta streams or anybody's streams, right? But I have reviewed the relevant part, the one part with the one legal issue that Nick was important to bring up, the one bit that was good for me to debunk, because it's a point I'm going to need to debunk, not just for Nick, but for all other lawyers. It's a point that needs to be slapped down. And we're going to get to that in just a second. Scotty Joe for $4.99 says, hey, you should have added a speech bubble for Rekieta singing to Mandy. And if Gina could be in the image slapping him with a catfish, chef's kiss. No idea what you're talking about. None at all. None at all. But the thumbnail, I will say, I'm not always, I don't always laugh, but that was a cute one. That was a cute one. I'll have to do one of like everybody in LawTube with like rainbows and butterflies and hugs next time. That'll be better. No one will be salty with me. All right. So we're going to start with talking about what this issue is. So what was the issue that came up that it was important to bring up, that Nick brought up, that we need to actually consider here? Well, the issue is whether or not this was covered by an anti-SLAPP statute. Now, before we talk about this, right? Before we talk about this, we do need to understand what a SLAPP lawsuit is, okay? So you need to understand what that is. You need some basic education. So this is going to be very educational for you guys who may not know what SLAPP lawsuit is. You may have no idea what that means. Well, SLAPP stands for Strategic Lawsuit Against Public Participation. There's a very cute video here that was put on by the Fortify Rights Group, and I'm going to play that. It's a 1-minute video, but this is what a SLAPP lawsuit is. It is not Will Smith. Will Smith is not the SLAPP lawsuit. So here you go, guys. A little cute educational video, about 1 minute and 43 seconds on what is a SLAPP lawsuit.
SLAPP stands for Strategic Lawsuits Against Public Participation. These are lawsuits which utilize the legal system to intimidate, censor, silence, and harass critics or opponents.
So let's understand this first of all. So a SLAPP lawsuit is something that is used to silence others. So the first thing you want to ask off rip is the intent, right? Is the intent in a broader sense? Step back. Let's all step back from this. Is this lawsuit being brought by Gina Carano to silence Disney? No, it is not. It is not. Gina Carano's lawsuit is not being brought in a broader sense to silence Disney's speech. It is actually to be made whole for Disney's attempt to silence her speech. So in a broader sense, stepping back, and we're going to narrow in. We're going to go right into the law. It doesn't fit what would normally be conceived of as a strategic lawsuit against public participation. So just from a very broad general sense, we're going to continue. We're going to narrow it down.
Simply speaking, SLAPP suits are a form of legal bullying. The most vulnerable to SLAPP suits include human rights defenders, political activists, victims of violations, communities affected by development projects, academics, but it really could be anyone expressing their views.
Okay, so let's go back there, real. So these are the most common groups, right? The most common groups are people who speak up. Let's say you were a person who was an activist and you were speaking up against the transing of children or trans bathrooms. So Let's say you were speaking up against trans bathrooms. You're an activist. You're actually technically an activist who's against trans bathrooms. So if the board, the school board, sued you for speaking up about trans bathrooms or saying something about them and their belief on trans bathrooms, that would be a strategic lawsuit against public participation. Okay. So that would be clear. That'd be a clear case, right? But these, of course, are not the only groups. The video said that. I'm saying it too. These are not the only groups. Yes, corporations can also be subject to SLAPP lawsuits. Just because it's a corporation doesn't mean that they're not covered by SLAPP and anti-SLAPP provisions. So just so you understand. And of course, by the way, this is live, and we have 500 people almost here on YouTube, and we also have over there on Rumble about 100 people. So we're rocking around almost 600 people here today. So please smash that like button or the pussy. You can go either way. You can get the pussy. I don't mind. I don't mind the pussy over there. Or you can hit it on Rumble or on YouTube. Pussy on Rumble, like button on YouTube. Hit it.
Reviews. Ever used social media? You could get slapped.
So there we go. So what we're going to talk about today is whether Disney's use of social media is covered by this statute, right? Is covered by the anti-SLAPP California statute. We're going to look at that specifically, right? And social media would indeed fall within this ambit. I do agree with that. Social media in general. Now, whether or not the specific Disney tweet does, well, that's a question.
SLAPP suits infringe primarily on the rights of freedom of expression and the freedom of assembly and association.
So what we have to look at is this intent here to infringe on your freedom of association? Oh, I guess Rumble wasn't working. How weird. Okay, let me see. I think I got it going. Okay. Think it should work now. Sorry, Rumble.
This shrinks space for healthy discussion, dissent, and debate among civil society. That's you, by the way. Thinking strategically, plaintiffs commonly file cases in districts far away from the defendant's location, bring multiple cases against defendants, or drag cases.
See, and that's what, by the way, you know who normally does this type of stuff? Disney. Disney normally files a bunch of cases all around the US. That's actually one of their basic moves. Disney will sue you in all 50 states and be like, deal with it, bruh. Like, that's what Disney does. That's their tactic.
In court, increasing financial and emotional strain. The resulting burden on defendants is immense, and yet SLAPP suits can start from just a single tweet.
So there we go. So the suit can be based on you tweeting something and other people thinking, hey, wait, that's defamatory, that hurt me.
It's the big guy versus the little guy.
Not always, and it doesn't have to be. It can actually be reversed, right? So technically it could be a little guy against a big guy, but they're probably going to run out of resources, right? So if you don't have enough resources, you're going to run out. Now, in this case, since we have Rumble, suppose that Rumble's not working? Come on, guys, come on. Let me try to fix this. But in this case, since we have Elon Musk, it's really big guy and big guy. It's not big guy and little guy. It's really big guy and big guy. So let's back this up here for a second.
It's the big guy versus the little guy. But it doesn't have to be that way.
Okay, cool. So that was a SLAPP lawsuit. So hopefully you guys understand the basic parameters, some basic education day. We're doing some 101 today. You know, you can't just jump into this stuff raw. You got to have a little 101. You got to have a little 101. Let's get these here. Fallen Hero with the $3 super sticker. Thank you so much for the shibas. Appreciate that. Arigato gozaimasu. 200 Watt Studio says, let's see what you got. Nick spanked you last night. Okay. I don't know whether he spanked me. We're going to go over the one good point he brought up, the very one good point. The rest, it seems, of his analysis in general, and we'll look at right now, seemed to just go back to a defamation analysis. So it seemed like other than this one salient point, the rest was really analysis that was applicable to defamation, right? That would apply in a defamation suit. And to be very clear, this is not a defamation suit. So I know that we've all gone in the world of Amber Heard, right? The world of Vic Mignogna, the world of Kyle Rittenhouse. This is none of those cases. So I know it can be confusing. And look, for people who cover a lot of cases like myself, it can sometimes be confusing. So it's understandable when people get confused because they don't really look deeply into the facts. They're trying to cover many cases, right? So it is understandable. But if you're going to make a legal analysis, you got to prepare for it to be debunked, right? You can't get salty when your legal analysis is eviscerated. Just Eat Her Cake gifted 5 Legal Mindset memberships. Thank you so much, Just Eat Cake. That is Legal Layman, Camcret, Psychodolics, Stephen H, and Watts Mamie. Welcome to the BLM. And you guys are obviously based AF. Leprechaun Gold, thank you for the $5, the $10 super sticker for a Shiba. And then yet another Shiba. Thank you so much for the 15. We just dogging it now, baby. All right. So here we go. So we're getting into what I thought was Nick's most salient point. Now, once again, I don't think doing all the defamation analysis was great. I don't think the rest of it was really useful. But this point right here is one that needs to be debunked because I think a lot of people who may look at this and look at this statute and they're not lawyers may say, oh, wow, this might be a problem. And, when they look at, a channel like who's a lawyer and applies this analysis, they might incorrectly assume that this applies to this case. So it's important to debunk this, but it is also good that Nick brought it up because I hadn't brought it up before. So it's good to defeat this and it's good that he raised this. I'm glad he raised this because I needed to blow this out of the water, right? This is something that I have not blown out of the water. So I have to do it now. I have to actually do it now. So here's where he pulls up California's anti-SLAPP statute. And we are going to pull this up ourselves, but I'll let Nick talk for about a minute here.
Legislature finds and declares that there has been a disturbing increase in lawsuits brought primarily to chill the valid exercise of the constitutional rights of freedom of speech and petition for the redress of grievances. The legislature finds and declares that it is in the public interest to encourage continued participation in matters of public significance. This participation should not be chilled through abuse of judicial process. This end, this section shall be construed broadly. Now, this is really important because I know what you're going to say. You say, but Gina's exercising her free speech and Disney stepped on it. Yeah, I got it. But the government isn't chilling Gina Carano's speech. Disney is, but Disney is chilling Gina Carano.
Sorry, I muted myself. I was eating here. Sorry, I muted myself. So Nick brought up the government. The government is completely irrelevant to this. So whether or not this is a government or a corporation, completely irrelevant. So the mentioning the government, which probably was just a matter of course, maybe. I don't know why he mentioned the government. It's not really relevant to the legal analysis of whether the SLAPP lawsuit is okay or not okay, right? So that's not really relevant whether it was the government or not. So let's continue here.
Carano's speech with their own effectively political speech. If you understand that their removal of her speech or their, their criticism of her speech and their lawsuit or their public statements about it is based on speech. She doesn't call it defamation, but it's still based on defamatory statements.
No, that's where Nick is wrong. So that's another point where Nick is wrong, but he's reading the statute right. The statute exists. He's just reading it. So he's reading it correctly. But his analysis that he applies going from the reading is wholly incorrect. So Gina's claim is not only based on defamatory statements. Let me say that one more time. And I've got a presentation at the end of this, and we're going to read the relevant case law. We're actually going to get in the case law that applies the statute, not just what he got off of Googling anti-SLAPP, right? Because this is from a website that is probably the first thing that comes up if you Google California anti-SLAPP. So we're going to go to the actual case law, the California case law. So in this case, there are many facts, most of which are not speech. So let me say that one more time. Most of the facts that support Gina Carano's claim are not speech. In fact, no speech is required to find Disney guilty on all 3 claims. One more time. No speech is required The actions of Disney alone, absent the speech, are enough to find Disney liable under all three claims in California, right? So that's the one thing I want to make very clear there. It's not springing from, and we'll see that language in the case law. It's not springing from the speech. The speech is incidental to the actions that Disney took, which damaged her and her future career. So I'll play this last part, and then we're going to go into a deeper analysis.
Cause of action against a person arising from any act of that person in furtherance of the person's right of free petition or free speech under the United States Constitution or the California Constitution in connection with the public issue shall be subject to a special motion to strike. So here's the thing. Gina Carano makes public tweets using her celebrity status to say something. All right. Disney terminates Gina Carano and says her tweets are offensive, anti-Semitic, not well considered, all these things. They say all these.
There's one tweet. So to be very clear, there's one tweet that's referenced specifically by Disney, not a bunch of things. There's one tweet specifically. We're going to look at it. We're going to look at it in the record, right? And to his defense, I think when he was saying these things, he hadn't even gotten to that fact yet. I think at this point in the analysis, he hadn't got to that. So maybe he didn't know yet, because I don't think he'd scrolled down far enough in the complaint. So I don't think he actually had the facts that would be relevant here when he made this analysis. So yeah, there's one single tweet, but there's a lot of actions at Disney. Come on.
These things, you can disagree with it all day, but that's part of the claim, if I'm not mistaken. Specifically,
he's mistaken. He's mistaken.
That they say these things.
The claim has nothing to do with any defamatory intent or any sort of malicious intent or any sort of intent to defame, right? So there's nothing that is defamation is not required by any of these causes of action. So Nick gets into this anti-SLAPP statute, right? And I'll pause it. I'll actually probably stop it there because, you know, he goes on and we don't need to see, you know, hours of lawtism to focus on this one good, very good point. So we do need to bring up the anti-SLAPP statute. And we do need to address why Nick is wrong about this, right? So this is the same statute. This is the actual case text, right? So you always want to make sure that instead of going to a website of some sort of activist organization, that you actually go directly to the source, or at least to the case, the more updated text. This is current to the 2023 legislative section. So I assume it's the most updated, right? It's on somebody's website because obviously a website can have an older version, right? So, and statutes are often updated. They can be updated year to year, right? So it is right that this cause of action, right, arising from any act in furtherance of a right to petition of free speech. So employment actions can be covered by this. So Nick is correct. Nick is correct that employment actions can be covered by anti-SLAPP laws. However, the case law is very, very clear on how you deal with anti-SLAPP in the context of employment law, right? And we're going to get into that reviewing the Smith versus Williams-Sonoma case, right? We're going to get into that. But let me get these super chats first. Beep, boop, boop, arg is a member for 6 months. Welcome. Thank you. Good to see you. Just sending that chat. Weird says, I think BlackRock is using Disney as a shell company in a proxy war. Tencent has a lot of shares of Epic. Disney would be a good cover. That's very interesting. I think I've said this before. I think there's puppet masters pulling a lot of these strings because these things go together. A lot of these companies, if you zoom out and you see what they're doing, it actually works together for the same agenda. One thing I was talking to my good friend Ben about today is that, you know what's funny? You know what happened with all of these companies getting all these woke workers and doing DEI? Well, they're replacing their workers that maybe were competent at one point with incompetent, unqualified workers. And those workers because they're not producing, it's easy to justify firing them to replace them with AI because they're not efficient. They do no actual results. So eventually companies will be able to shift everybody out for AI. And then you fully replace the workforce. The competent people are gone, right? They can't get a job. And the incompetent people are the only ones left in the company. But AI can replace them because they don't produce anything of value. So AI will always be able to prove that it's valuable versus an incompetent worker. Now, a competent worker could probably beat modern AI. Could probably outthink it, but the workers in there are incompetent. Very interesting. There's a lot of stuff going on that can be shady. Squizigar 2322 says his point about the government was that Disney was not using the government via lawsuit to chill her speech. Yeah, but once again, I don't think it's not relevant whether or not the government was used. You can still apply anti-SLAPP in a corporate scenario, right? So you can apply anti-SLAPP if, for example, a corporation was trying to stop the speech of an individual, or a corporation is trying to stop the speech of another corporation, right? So I get the maybe I get the relevance a little bit more, but it's not applicable to these facts, right? So that's not applicable here. Calhoun says, sounds like he's confused. This is a termination, harassment, discrimination suit, not speech or defamation. Yeah, and I understand, because look, we cover a lot of defamation cases, right? Like I mentioned, Amber Heard, Johnny Depp, Vic, Kyle Rittenhouse, right? Who's now doing a defamation case. We cover all those. So I get that we're used to, in our heads, thinking defamation, right? Defamation, defamation, defamation. And look, defamation cases are fascinating to cover, but this is not a defamation case. Even though it uses the word defamation, which may or may not be a smart choice on the part of our lawyers, it may actually be confusing that they use the word defamation. I can see that. They may intend to try to add defamatory if they find more information they could sue on or add that to. Maybe, but maybe not, right? Justin Martin says, were Disney's lawyers hired by DEI standards? Could be a good one for Gina if that's the case. Maybe that would be kind of proof right there. And once again, remember, and I've said this time and time again, and I'm not sure whether Uncivil talked about this or Nick or anybody else, but victory is discovery here, guys. Victory is bringing a light to this. It's not necessarily a jury trial victory. Really, like, to me, it's surviving these preliminary motions. So surviving a motion to dismiss, and by the way, surviving an anti-SLAPP motion. Because, by the way, I don't doubt that Disney's counsel will use every trick in the book. They may try to use an anti-SLAPP motion. And I'm glad I already have a video, thanks to Nick. I'll already have a video ready on why they will lose that motion. Thank you, Nick. I appreciate that. You anticipated Disney's argument, and you gave me a chance to preemptively do it, because he was taking the Disney side. He's kind of steel manning Disney, right? And I'm debunking that. So that's a good tete-a-tete, if you will. All right. So what happens in California if you have an employer, right? So if you have an employer, and this is in an employment lawsuit. Well, we have this case here involving Smith versus Williams and Sonoma. This is a California case, right? It's in October 2021. So this is a recent case. It is a relevant case. It's California once again. So this is not, Wisconsin. It's not Florida. It's not Texas. It's a relevant, on-point case which would need to be considered by this court. So what it talks about is, in this case, there was a woman, Kelly Smith, who sued Williams and Sonoma, WSI, Williams and Sonoma. Of course, you want your bougie plates. You want your bougie spoons, You got to get fancy. You got to go to Williams and Sonoma. So she sued them, alleging workplace misconduct. She claimed sexism. She claimed all sorts of discrimination. WSI moved to strike the complaint as a strategic lawsuit against public participation. So they allege that her employment lawsuit was actually a SLAPP lawsuit. Now, they go into here the purpose, and this is very, very important. This is the first thing they say. An anti-SLAPP motion is a procedure for weeding out at an early stage meritless claims. So if the claim is completely meritless and it's meant to chill First Amendment rights, they want to get rid of it. So that's the intent here. And what was protected, the speech of Williams and Sonoma, was their filing of a police report and their calling of police. So their speech related to reporting people to the police was protected. So this girl, Smith, She worked at Williams-Sonoma since 2005. She left shortly, but she came back. She worked there from 2012 all the way through, right? Until she was a leader in 2018. She supervised 30 employees, but she claimed she had no real management duties compared to her male counterparts. She believed men are paid more. She asserts there was a hostile work environment, that women were at entry-level stores, that they were not promoted, and they were treated without respect. So she alleged all of these facts. Okay? In addition, she included in her complaint the fact that they reported her to police and they prepared a police report. Right? So they had 13 causes of action, 6 violations of FEHA, wrongful discharge, defamation, emotional distress, malicious prosecution, and abusive process. She threw everything at them. And it turns out that she was actually kind of dirty. She was involved in this scam where she would mark goods as scrapped, which means they had zero value. And she would turn them over to her homie, Mr. Wong. Not Wang, guys. Not Wang. That's racist. It's Wong. Keith Wong. Right? Get it right. So Wong was supposed to donate these goods that were marked scrap to Habitat for Humanity. But instead, Wong drove them to his home. Right? The drivers took the trailers to his home. This was discovered and reported to police. Okay? So what the court looked at when they were looking at this and saying, what do we want to strike here? They applied a 2-step SLAPP analysis. They said that the statute applies to any statement made in legislative, executive, judicial, or other official proceedings. So police conduct would happen, or any other conduct in furtherance of the exercise of a constitutional right or petition, or the constitutional right of free speech. So that could be a tweet. That could be a tweet. If it's related to a public issue or a public interest, it can be related to that. But you have to do 2 steps. First step, step 1, you've got to look at the defendant. Disney has to show, in this case it was Williams-Sonoma, but Disney has to show that the claim is based on a protected activity. Right? That the claim is based on a protected activity. So we're going to look at Gina's claim and see whether her claim is based on a protected activity. We're going to look at that, right? So that's step 1. Step 2, they have to say, okay, is the plaintiff still going to prevail on their claim? If they can still prevail, what you do is, and you look at the bottom here, when you go to the issue here, when you see what the ruling is, what you do is you strike anything that is related to that. So you strike anything protected, but you allow them to amend their complaint. Look at what they did here. So Williams-Sonoma actually won this one. They won that the police report needed to be removed, right? That the theft and fraud investigation needed to be removed. So Williams-Sonoma won. This is like Disney's wet dream, right? So if Disney won, this is what would happen. They would just need to file an amended complaint removing the references to, in this case, was theft and fraud, right? So all they would need to do is file an amended complaint removing the tweet. And not even the whole tweet, just the part of the tweet that references the protected speech. So let's look at the tweet itself. Let's actually look at the tweet itself in the complaint, right? Because that's an important fact here to actually look what was said, okay? What was said by her? What was said by Disney that could be protected? The thing that Nick is hanging this all on is this tweet right here. So there's a tweet by Disney that said this. Let me show it. So here we go. In announcing Carano's termination, Gina Carano is not currently employed by Lucasfilm, and there are no plans for her to be in the future. Nevertheless, Her social media posts denigrating people based on their cultural and religious identities are abhorrent and unacceptable. So this is the one tweet that Nick is saying can win everything because it's anti-SLAPP, right? The problem is for this argument is threefold. But before I get to the threefold reasons, we got a lot of memberships here. Is this live coming in with 20 legal mindset memberships and Tank Rat coming in with 50 legal mindset memberships? What's going on? We're 70 in, guys. Rolling deep, rolling dirty. Shout out to the BLM, most based chat out there. Thank you so much. Let me read a couple of these. I'm not going to be able to get all of them, but let me just read a couple here. So for Is This Live, Yogi Bear, Florida Meth Gator, Psy, Neurotic, Burnt Toast, Remus, Cheesy Tarian, K Nakajima, Current Event Nerd, Simply Green, Cheers GXP, Billy W, Three Beers, Steve Olo, Ariska, the Dapper Goose, and Thomas Mess. And then going down here for Tank Rat, the freaking Gucci 50, just a couple of these. Scott Marshall, Miko, Rover Boy, two Bros Boy, Jesse J, Khan, Ultra Maga Dude, Jason, Carl, Bridget, Quantum Videos, Paul McDermott, Kevin Vassar, UX Dutch Kitty, Jim Webb, Andrix Leave, Ghost Fox, Alan Green, Jonathan Bento, Mac Sean, Scrap Hermit, and Wolfsbane. My long homie Wolfsbane. Good to see you guys. Lots of others there too, but guys, it's too much for me to even handle here. I'm overloaded. We got too much. And then Muskie comes in with a 20. What do you expect me to do? Muskie, thank you so much. We're getting to we're pushing here. 95 in 37 minutes for speed. This is the most we've had in 37 minutes into a stream. We are not to like the longest stream because I've done like 4-hour streams. We get a lot of memberships. That's fine. We're breaking a land speed record. We're going 0 to 100 real quick. We're actually at 95. We're almost at 100. But we are going 0 to 100 memberships real quick. Muskie Skeleton, thank you so much. And real quick, for those that were hooked up by the muskiest of skeletons, Inglaterra, Rebellion Wolf, Hugh Janus. I think he meant Hugh Janus. Aiden McLean, Aaron Howell, Aaron Larg, David Walker, Narcissus Khan, and Moby Moo, Doug, Spartan's Bar, and Elder Scold. You guys all were hooked up by that guy. So there you go. Say thank you to everybody. So thank you to all of these guys. They're really good supporters here. And thank you so much for supporting the channel. You guys are great. You guys make me able to do this on a regular basis. Easy 007 saying, having watched Nick's full stream, he hasn't got that in. And all he's seen so far is speech-based, so hasn't gotten to the core of the complaint. And maybe that's the problem. I don't know. I mean, maybe he's going to continue, which I hope he does. I hope he gets to more facts. I hope he gets to more relevant facts and gets into it. And I hope that he understands that there's more facts here. And by the way, there's facts that aren't even in the complaint. When we get to the actual stuff that's beyond the complaint, stuff like, for example, Gina Carano reported that there's stuff like her hairstylist, right? Not reporting on time, not doing her hair, screwing things up. People like her makeup people, right? Her makeup people were like screwing up her makeup, doing stuff like, it was disparate treatment. The employees were harassing her. They were doing things to piss her off. They were treating her poorly. It wasn't just the speech, right? My speech. It wasn't just my speech. If it was just that, then it might be an issue. And that's because this is not defamation. We're going to get into those 3 reasons right now. Weird says, if this AI angle is true, it's going to be government intervention. AI doesn't pay taxes. People do, and poor people can't pay taxes. Weird. You will own nothing and be happy. UBI, Universal Basic Income. How do you think they get that in? They get that in by saying, hey, we're going to put AI in, but with the cost savings from AI, we're going to pay you all UBI. And then we're in a socialist hellscape. Okay? It's an easy, you can see, it's like a layup, right? That's the 1, 2, 3 punch, right? Fire competent, knowledgeable workers, ethical workers, fire them all. Kill small business, kill medium business. Only big business remains. Big business, get rid of all good employees, keep only shitty employees. Justify firing shitty employees, replacing them with AI. Everybody is now fired. Nobody has a job. Give them all UBI. You have to follow the rules. We monitor your bank account. You can only spend it on what you want. Insert current thing here. this is an apocalyptic woke hellscape. Yes, that's a very easy. It's easy. It's a path. It's a clear path, right? It's kind of like obvious almost. Bella Stella, thank you for the 50 Legal Mindset memberships. Appreciate you so much. Bella, you are just a great supporter of the channel. Thank you for hooking everybody up here. And then I would be remiss. I'll read right away. Brian Gibson has 10. So thank you. Guys, we are already at 155. We've broken a land speed record here on the Legal Mindset. And guys, this is a quick stream. We're not going to have a 2-hour stream tonight. We get in, we get out. I don't dawdle. I don't sit around and have I'm eating here a little bit. I haven't eaten dinner, so I got my chicken and rice here. I'm eating a little bit of. It's got a little spicy sauce. It's kind of good, but I don't linger, man. We move here. But I will read some of these memberships because it's a thank you to those that donated them. Strangle, Paul Garrett, Loud Bob, Jackie, Cheshire, Andrew, Tom, Adam Strang, CHJ, Sean, Crosby's Gaming, Michael, Scott Coleman, Matt B, Kit Walker, DB, Stutters, Michael Barber, Mike Johnson, Liam, John Smith. You guys all say thank you. Iron Griff. All you guys say thank you to Bella. Bella hooked you up. Vinzinger, and all you guys got hooked up by Bella. So let's say thank you to Bella. And then a couple of you that I can read down here, I believe, got hooked up at the end. Actually, hasn't even updated for me. But thank you guys. Thank you, Brian, and thank you, Bella. Appreciate both of you. Brian, yours like got mixed up in there. So, but appreciate you and thank you for that. So many members. We got a sea of green out there, and it's because of members like Bella, Is This Live, Tank Rat, coming up big day to day. Thank you guys. And we will have another members chat soon. In fact, we may even have a Rumble exclusive. Tonight. Also, we do have, before I go any further, we've got some Rumble rants. I'll get to these, and then we're going to get to my 3 main arguments. So Roki Hara said for 2, Rackets claim the underlying cause of action is still defamation, but doesn't sound right. It isn't. So he's wrong if he says that. The underlying cause is not defamation. If he keeps saying that, then it's wrong. I didn't hear that. And the fact that he's bringing up SLAPP, and I think he brought up this now, I guess. So we'll see if he changes his tune. Is a suit alleging Disney fired me for a tweet or Disney fired me for my perceived political association? It's the second, right? It's the second. It's for political activity. They fired her for her protected political activity, right? It's not just, it's not one thing they did. It's not even that they fired her. The firing is just one fact. The struggle sessions alone would be enough to sue under California labor law. We're going to get into that. The second Rack's claim was that California courts have narrowed the statute's interpretation to just pro-gay activism. Yeah, here's the problem, which I hope Rackets didn't say this. I hope he is paying attention. This is a federal case. This is not a California case. So this is in federal court. They cannot do the biased shit they would do in a local court. Also, some people, Californians, I want to give some credit to Californians, especially based Californians. They do exist. They often live in the rural areas and the farms, and those farmers are often what's feeding California. What's keeping California alive is red California, not blue California. But those red Californians are there technically, and if this ended up in a red Californian area, technically it could proceed, right? But this is a federal case, so it does not apply to the same biases there. So that's an important nuance that needs to be acknowledged when we're looking at the case. And also shout out to everybody who's there on Locals and on Rumble. We've got 185, and over here we got 900. So we're over 1,000. Make sure you smash the like button and getting into this. So let me get into my neat little presentation here. I made a cute little, I do my homework, guys, sometimes. I made a cute little PowerPoint here for you guys on this. If it will actually present. Come on, present. Let's do this. Okay, here we go. Okay, guys, here's legal PowerPoint on why anti-SLAPP does not apply. All right, so we're going to get into it today. I like making PowerPoints. Actually, oh, by the way, Cash says, what calls you and Nick to fallout? No fallout. No, this is me. Don't misunderstand, Cash. This is me having a problem with his legal analysis. This is not about Nick as a person. People can think how you want as a person, right? You can think Nick is bad, Nick is good, Nick is whatever. That's your choice. I don't give a fuck what you think about Nick or don't think about Nick. That's your own choice, right? But what I am critiquing Nick on is his legal analysis. Let me be very clear. This is not ad hominem of Nick. I know some people out there. I know you guys. I know who you are. I know you guys, some of you want ad hominem attacks. You want people to come at people with personal attacks, people to call them names, people to say that. All I am doing is giving an alternative, different legal analysis. That's it. right? And his method of legal analysis and his perspective. That's all. There's no personal part of this. I don't care. His haircut, which is probably very similar to mine anyway. So whatever, right? None of this is about this. It's about the law, right? So why does anti-SLAPP not apply? This is a legal analysis. These are the legal reasons, right? 3 reasons why Nick is wrong, but more generally, why anti-SLAPP doesn't apply. There are 3 main reasons here. First of all, number 1, this is not a defamation case. And I know what you're saying. Well, legal mindset. That California statute doesn't just apply to defamation cases. Oh, that's correct. But it's a fundamentally different analysis when it is a defamation case versus a not defamation case. It's a wildly different analysis. So when you are looking at this mistakenly as a defamation case, you're completely wrong. But even with the anti-SLAPP defense, it doesn't protect you if it's not a defamation case. Second, and this is the case we just read, the Williams and Sonoma case, Smith versus Williams and Sonoma. The claim does not spring from protected language. So the claims do not originate solely based on Disney's tweet. So Disney's tweet is not the origination of the problems here. It goes beyond that. And third, even without the Disney tweet, so even if Nick was 100% right, so let's assume Nick was right, that wouldn't bar this claim. Let's pretend, let's put on our suspension of belief and believe that Nick was 100% right about the tweet and it was protected under anti-SLAPP. Gina would still prevail. That's what is the biggest thing that defeats that argument. So let's look at this. Let me explain it like a child, because sometimes lawtism needs to be explained in a very childlike way. So let's do this. Defamation case, right? This is a defamation case. So a person says something defamatory. So maybe you say, hey, you're a felon. Hey, you have AIDS. Hey, you're guilty of domestic abuse. That was Johnny Depp and Amber Heard, right? You're guilty of domestic abuse. You're a sex abuser. You're a criminal. That's defamation, right? So in a defamation case, something defamatory is said, and then the person or company who is damaged by that sues. So let's go to the analysis and let's apply anti-SLAPP. So let's say that something was said, but it's protected. It's protected speech. Let's say it's a tweet that says, you are a nasty, evil Republican. Or let's say it says, you love Joe Biden. Or let's even say this, Bud Light. Remember Bud Light? You know how many people attacked Bud Light? Why didn't Bud Light sue everybody? Why didn't Bud Light sue everybody? Because that would have been covered by anti-SLAPP. Because that would have been protected speech. There's no claim. There's no claim. You have to have that speech. And then once that speech is wiped out, no claim. Now, you can have multiple tweets or multiple statements that led to defamation, and then you'd have to analyze each one in a case-by-case basis. But a defamation case with anti-SLAPP, it gets wiped out. But that's not what we have here, guys. It's not what we have here. What we have is Gina Carano's case. This is Gina Carano's case, okay? Let's see what we have here. What we have is Gina Carano. See, the first was just an AB, right? This is ABC. Gina Carano makes various political statements. She makes statements about COVID. She makes statements about voting. She makes statements about about online bullying, right? So Gina makes various political statements. She's exercising her First Amendment speech. And then Disney, as a company, reacts in several ways. And I have another PowerPoint that blows these up, that blows up these facts, and we'll focus on the facts. But it's important to understand that this is A, Gina speaks, B, Disney reacts. Okay? So what does Disney do? They chastise her in private. They attack her. They require a mandatory re-education. They want to put her through mandatory re-education. They want to They allow employees to harass her, to mess with her, right? Next, they required her to attend a struggle session. They tried to get her struggle sessioned by 45 employees. Can you imagine that? 45, saying we're going to put 45 gay employees and let them yell at you at how you're a bigot. That's a struggle session, right? And you guys know I'm no fan of struggle sessions. And that was a Disney activity. That was not a speech. There's no protected speech. There's no public speech there. And then you get to the one fact that Nick brought up, the one fact that could be covered by anti-SLAPP. Could. I'm not saying would, but the only one they can bring up the anti-SLAPP defense on is the tweet that calls her abhorrent. We're going to look at that. We'll look at it again, right? Is that tweet calling her abhorrent. They then terminate her contracts and they then cancel her future content. And then Gina Carano sues. So look at the difference here, guys. We have AB, right? AB. This is ABC. Can you see how these are different? These are not the same. So let's pretend once again that Nick is right. Let's pretend he's right. And the tweet that is calling her abhorrent is struck. Look what happens. Do you see the difference here, guys? What's the difference? What's the difference? They amend the complaint and they take away that one tweet. And they might not even take away the whole tweet. We're going to look at the tweet in a second. I don't think they would even redact the whole tweet. I think at most they would redact part of the tweet. Not the whole tweet. Or they'd at least allow the reference that she was fired by tweet, because that's objectively true. It is a fact that is not political at all. It's just a fact that she was fired by tweet. That's a statement of fact. The action that can be reported regardless of SLAPP is that she was terminated by tweet. The content of the tweet is irrelevant. The calling her abhorrent doesn't change the analysis. She still can sue under California law, even after all that. Labor claims do not require defamation. They don't require malicious intent or defamatory intent. Actions are the focus. And one fact alone, one of these facts alone is enough. And you can see here all of these facts: chastising her, re-education, struggle sessions, harassment, ignoring similar behavior by male coworkers, sending the tweet, terminating her contract, canceling future content. Even if you take that out, you've got all that. One is enough. They have 7 others. And that's me probably not even getting everything. Probably not even getting everything. This is just real quick, without discovery, what we've got. And mind you, this right here, ladies and gentlemen, is before discovery, and they only need one. And this is a statute where, as we heard from Ian, who was on that law panel, right, gave him an S tier ranking. So from Ian, this is pretty straight up. You do these things, and you are guilty under the statutes. You're convicted of the statutes, right? You have liability under the statutes, not criminal or civil, right? But let's go back here. Let's go back and look at the actual statute to make sure we're applying this correctly. So when you look at the statute, here's the statute, wrongful discharge. Does this statute say anything about defamation? Where's the word defamation in this? Where is the word requiring defamatory intent? This does not require any of that. All it requires, look at this, the employer make, adopt, enforce any rule, regulation, or policy. Make, adopt, or enforce. Where does this require speech? Where does this require speech? It doesn't require it at all. This does not require speech at all whatsoever. It looks at the actions that might forbid or prevent an employee. Would going through a struggles, let's go back here. So it's forbidding or preventing employees from engaging in politics or controlling or directing or tending to control or direct the political activity. So let's go back to the facts. Right? These are the facts that are alleged in the complaint, which, people can see. Say, look through, right? So let's prevent this again here. I'm going to throw this up right here. So These are all actions, right? You can look at the action of terminating our contract. Would chastising you privately, here's a question, would chastising you privately tend to curtail your speech, your political speech? Yes. Would requiring mandatory re-education chill your speech? Would have the tendency to chill your speech? Yes. Would struggle sessions do that? Yes. Would harassment do that? Yes. Would ignoring similar behavior from men? Yes. Would terminating the contract? Yes. Future promise, canceling future promise content? Yes. All of these things are sufficient to sustain it, right? One fact alone. Doesn't need speech. Doesn't need any speech. It's irrelevant. Is this live says here, you don't arrive at that tweet without there being dozens of emails that she will introduce with discovery. And we're going to have so much more. That's why people who are following this, people who have been into this know it, right? And once again, I don't blame anybody who hasn't been following it for not knowing it, not knowing what evidence is there that we know is there. It wasn't included in the complaint, but it is there, and we will get it with discovery, right? There's more. Cash says, no intent behind my question. Just curious. No, all good, bro. I don't take offense at super chats. I'll answer your super chat. May not be in the way you like, but I'll answer it. Leprechaun Gold, thank you for the $5 super sticker. Appreciate you. And guys, make sure you're smashing the like button here today. We got only 468, not even 500 likes. Come on, guys. Come on, let's get it up. Let's get it up. And then Pappy G says, could it lead to defamation after discovery? Yes, it could, if there's new information. I think they'll keep it at labor law because it's easier. It's easier to close out this case as a labor law case. The Texas vet says, I decided to check out what my legal mindset stream was talking about in between corporate training and PowerPoints. And what do I see? More PowerPoints. Death by PowerPoint. Military vets get it. Just tease. Love the hard work. Guys, I do the research on this. I do the background. And look, if somebody challenges me, I'm going to look up the case law, right? I'm going to make sure that I do my research because I think that's the duty of us as legal presenters, as lawyers, to go beyond what a layman says. Look, laymen can still have opinions. You're allowed to have an opinion, but when you frame it as a legal analysis, it's subject to legal scrutiny. It's subject to the scrutiny of others, analyzing that legal logic, analyzing in light of the case law, in light of the facts, right? That is what it will be subjected to. So don't expect not to get your stuff checked, right? When it's wrong, right? Patently wrong. So that's what happened here. Zion says, not a fan of the drama. Appreciate facts. There's nothing but facts here. This is not about drama. It's nothing about Nick personally. It could have been anybody. It could have been Joe. It could have been Nate. It could have been legal, right? This could have been legal. I don't care who brought it up. If you make an argument that is legally insufficient, I'm going to call it out, right? I'm going to call it out. It's just the way it is, right? And I'm going to apply it equally, whether you're my friend or not my friend, whether you're, whatever my personal relationship with you. If you have a bad legal take, call it out. Having problems getting it up, little phrasing. Yeah, I'm just saying. It happens. Based in PowerPoint pilled. Absolutely. And IUCP says, keep it the good work. I will. And obviously I love being challenged. I don't find it, guys, being challenged is energetic for me. I love to be challenged. Push me on these, please. Challenge me. Come on me, bro. I love it. Now, what I don't like is getting on panels and screaming and yelling. I don't like getting in fights with the chat. I don't like all that sort of stuff. I like getting into the actual analysis and being able to talk about it. And I can do that on my channel when I'm here presenting to you guys and can present a coherent, compact argument that people will understand and that will help educate, not just create clickbait content, not just create dramatic content. That's not my intent, right? Me and my monkey says, nice work, Andrew. I saw you doing different. Oh yeah, thank you. Welcome. So this is why that fails, right? That is going to fail. So once again, going back to that main three, I want to go to this cluster of three here, guys. This is this is not a defamation case, right? So I'll put this up right here. It's not a defamation case. The claim does not spring from protected language. So it does not spring from anything that is going to be protected. So this is not defamation, right? It's not coming solely off of the tweet. In fact, the tweet itself, not that important. I'll show you the tweet one more time. And then even without that tweet, the claims can proceed. The claims can indeed proceed. Let's look at the tweet one more time. I want to show you guys why I think this tweet would be just fine no matter what, why this tweet is going to make it and there's not a problem. I think this is kind of important when you're looking at this analysis, right? So let's look at the tweet again. Let's go to the tweet one last time. So here's what the court could do, and the court very well might do this. This is what's going on. The tweet says, Gina Carano is not, is there a way to, can I undo all the highlighting? Let's see. Can I undo the highlighting? There we go. Okay, so let's show you this, right? So Gina Carano is not currently employed by Lucasfilm, and there are no plans for her to return in the future. Nevertheless, her social media posts denigrating people based on their cultural and religious identities are abhorrent and unacceptable. So this part here is, so there's two parts here, right? This part here is the part that Nick is claiming is political. I don't think that and remember, Disney has the burden of proof of showing that this part is political. But let's say that the court finds that it is political to say that Gina Carano denigrated people based on their cultural and religious identities, and that's abhorrent and unacceptable. Let's assume that Nick is right. Let's take Nick's side on this, right? So what are we going to do with this? We're just going to strike it, right? We're just going to strike it. So let me see if I can just go here. So we're going to highlight, right? And let me see. Can I strike this? Strike it. That's what we have. Look at that. So if Nick is right, this is what happens. We refile the case and they literally strike that line. Oh God. Oh, Gina's claim. It's doomed. It's doomed because they struck that line. No, it's still fine. It's fine. The important part, the actual important part, the substance is this. This is the most relevant thing. Yes, Jeff, I'll be there in a second. Put in the tampon. Don't worry about it, buddy. I love you. XOXO. So in this is the most important part. This part right here. The termination and the fact that she's no longer employed. This comment isn't going to change the analysis. The fact that she was terminated is the material fact because that's what gives her the basis to sue because she said something and was terminated. Whether or not they were mean when they terminated her is irrelevant, right? Is irrelevant. So that's what we got here on the Legal Mindset today. All right, let me get the Rumble rants here because we got some over here that I need to get to because we've got people all over. And here it is. So Torgo the White says, can you clarify why this is a federal case? I thought employment discrimination for political affiliation was California state law. This is a diversity case, Torgo. Good question, Torgo. This is a diversity case. So diversity jurisdiction, federal courts can apply state law. Let me just restate that. Federal courts can apply state law. Look at the Disney case, right? They can apply. Well, in that case, never mind. That's a bad one, not that one. In diversity cases, they can apply state law. So diversity cases between people who belong to different states, Gina Carano's from Montana, Disney is California, and they're applying that to citizens of two states, and the amount in controversy is over $75K. They apply California law. So the federal court is going to look at California law and apply California law, even though it is state law, they can still do it. That's for diversity cases. If it's a federal question that is a constitutional question, then they would apply federal civil procedure. Rocco Hora says, I'm with you that it's a win if it hits discovery. Discovery suits are hard as fuck to find usually, but DEI departments are incompetent, ignorant of the law, and proud to discriminate. So there's a cornucopia. And that's what we're going for. You guys get it. You guys who are paying attention to this, you guys get this. You understand that the win is discovery. The win is not a jury verdict. The win is discovery. You guys get that. The people paying attention to get that. And that's what I'm doing this for. I'm just doing this for the people that know what's up. Speaking of which, I got to get over to Legal Vices. I'm late. Look, he's Korean. He's going to be mad that I'm late. It is what it is. I love him, though. He's a good guy, and I wish everybody $1 million. Guys, I will catch you on the next one. Smash the like button, and I will be back tomorrow. Peace.